purpose here today is to announce the efforts being made to preserve access to the Texas civil justice system by securing funding for this critical mission. Circumstances could not be more dire. As Texas' population has grown, so has the number of poor people who qualify for legal aid, now some 5.7 million. The hard economic times have increased the need for civil legal services as people can confront foreclosures, requests for medical treatment, other benefits, and the stresses that build up in families in such hard times and lead to violence. But the same economic problems have decreased available funding for civil legal aid. So we face triple trouble: an increased number of poor people, an increased need for civil legal services, and fewer resources to meet the need. When the need is not met, the burden to the state from homelessness, poverty, and family violence grows greater. The 2009 legislature gave the Supreme Court a one-time appropriation of $20 million, without which civil legal programs could not have continued to function. Even with the $20 million, drastic cuts were required. This year, we need that funding again, or substitute funding to preserve the mission of basic legal services. This could not be a higher priority for the Supreme Court. It is not a partisan issue. The court is committed, heart and soul, not only to making the civil justice system the best it can be, but to ensuring that everyone who needs it can get access, not just people who can afford a lawyer, but those who cannot. With me here today to discuss all these issues with you are Harry Reisner, who is the chair of the Texas Access to Justice Commission and a partner at the Vincent Elkins Law Firm in Houston; Jim Sales, chair emeritus of the Texas Access to Justice Commission and of counsel at the firm of Fulbright Jaworski; Representative Pete Gallego from Alpine and other places down there. Way down there. Jackie Pontello, someone who I've grown to know and admire, who is the executive director of the Aid to Victims of Domestic Abuse in Houston, and one of her clients to help us put a face on this problem, Crystal. We're going to ask Harry to speak first.
Thank you, Justice Haig. The Texas Access to Justice Commission was created by and has been completely supported by the Supreme Court in attempting to develop policies that increase free legal work for the millions of people who cannot afford it. We have worked with the State Bar at great length. The State Bar has responded magnificently. Texas lawyers give over 2 million hours a year, over $500 million worth of legal services free to those who cannot afford it. The State Bar has also created a Veterans Initiative. Our veterans returning from the Middle East have faced complicated mental, physical problems. They have difficulty getting the disability and medical care that they're entitled to from the federal bureaucracy. They have difficulty from people who try to take advantage of their absence. One of my favorite cases that my firm handled was an Army sergeant who was serving in Iraq, whose husband filed for divorce and claimed child custody because she'd abandoned her children. All kinds of people try to take advantage of veterans, and many of them desperately need our help. We also work in supporting the legal services organizations who close over 100,000 cases a year for people who cannot afford them, helping over 250,000 Texans. Well over half these cases, as Judge Hecht indicated, involve domestic problems, domestic violence, child abuse, custody cases, cases that can devastate and cripple a person's life and keep them from becoming citizens who can support themselves unless they receive the expert legal help that they need. Without new sources of support in this economy, tens of thousands of Texas will lose legal representation in desperate circumstances that can change their lives for the worse for the rest of their lives. So that's why we're here today at the legislature. And, my predecessor and hero for his work in this area, Jim Sales, is going to tell you about our efforts here.
Thank you, Mr. Chair. We're here, as Mr. Reesner has so articulately laid out, to try to raise the awareness and the need for funding from our legislative sources. Just to give some context, when I took on the chairmanship back in early 2004, we had 3.8 million poor people in a population of about 22 million people. Today, 6.5 years later, our population is approaching 26 million. It hasn't quite gotten there, but we have 5.7 million poor people, almost double what it was 6 years ago. An astonishing figure, and the legal service providers who are on the ground suggest that that is a real lowball estimate of what the reality really is. In 2009, we came to the legislature because the funding that is one of the primary sources for legal services is IOTA, interest or lawyer trust accounts. And we had been receiving approximately a little over $20 million annually based on the going interest rate at the time, back in 2007, early 2008. And then, as everyone in this room well knows, the economy collapsed on us, and the interest rate collapsed within a short period of a few months to 0.25 interest. And you can see on the chart the consequences of that drop. $15 million a year. And when you're operating on a shoestring to begin with, that is catastrophic. And when we came to the legislature in 2009, we pointed this out and said we need something to help us at least bridge the gap in appropriations, because we could not survive. This fragile system that we had built up could not survive that sort of catastrophic impact. And as a consequence, the legislature, after considering our request for $39 million in a biennium grant, finally resolved it with a $20 million biennium grant, for which we are and were eternally grateful, because it did not give us all we needed to operate, but it enabled us to sustain the system and to keep it from retrenching and in some parts of the state even collapsing. We are back to the same dire situation. We have a $15 million drop in our OLTA funding still, and it looks like it will be with us even for more years than this year. And in addition, the $20 million biennium grant has been utilized, so we are in essence losing another $10 million a year unless that general revenue grant is considered and granted. But with that $10 million loss, if we do not get it, will be a $25 million loss in operating expense, plus according to the budget that is presently pending, there will be another $3 million clawback that has to be also computed. To basically approach the situation and to come up with some positive recommendations at the request of the leadership of this legislature, we've come up with 4 proposed bills, which I will just briefly mention. I will not go into detail, but I'll be glad to discuss at some depth with anybody who wants to pursue it. One is a fee increase bill of $10 annually for district court filings. There has not been any fee increase in 6 years, and this would be the first fee increase in that period of time. It would be for court filings. The second bill will be what is presently called the Judicial Access and Improvement Fund. It is a little bit complicated, but fundamentally it says that anyone filing any document of record with the county clerk's office, such as assumed name, marriage license, anything to do with deeds of trust, whatever, would be required to pay a $2 filing fee. That doesn't sound like much, except when you take the whole state in totality, it's a significant sum. In addition, a $10 increase for any cases in the justice court, justice of the peace court, or the municipal court involving a misdemeanor. That would also raise money. The total, we don't know exactly, but hopefully at the end of the day, it could result in as much as $20 million biennium or $10 million per year. The third bill would be the Attorney General bill, which involves suits by the Attorney General to recover forfeiture based on violation of the Consumer Protection Act. That would produce roughly $1.5 million a year at the discretion of the Attorney General to divert to legal funding for access to justice. And finally, a bill that we filed in 2009 but is being refiled with some major modifications, and that's a foreclosure bill in which upon the foreclosure of a home, after the final foreclosure is completed, the money is transferred. There would be a $95 filing fee associated with that. And that fee would be payable out of the proceeds of the sale, not as a fee, but from the amount paid for the property. And the main point of that is that it would only apply to lenders of second and third resort. In other words, the local bank or the local mortgage company that funded the original loan would not be liable under this. It would only be the second and third mortgage holder down the road, which in many cases are the New York mortgage firms that broker these fees. So as you can see, we have tried to respond to the leadership of the legislature, which has been very sensitive to the importance and the need for access to justice. It's very fragile, and if we don't nurture it and get this funding, we truly jeopardize it. And as I have read before this individual speaking of this, I think it encapsulates everything we're talking about, and that is that justice is the most hollow of promises unless a person has access to the justice system. Thank you.